Yeah.
Thank you.
Alright, I'll send somebody over. Room 13, you said? Perfect. Yeah, we're off right back. Hey, room 12, 13, you tell them.
So we're gonna get started. As far away as we get. Folks hear me? Yes. Great, thanks. If you're here on the hair loss seminar, Tony's gonna be doing that next door.
Down pat.
We want to make this more hair raised and relaxed. So thanks for coming. My name is Tim Shearin. I'm a lawyer at Common Flaw. Next to me is Judge Moukawsher. And today's subject is reinvigorating the lawsuit. What it really is about is Judge Moukawsher's thoughts after serving for 9 years on the bench, 10 years on the bench. And it's come to some observations, some of which are probably not favored by the establishment, and some of which they probably should think twice about. This is going to be an open conversation. I may be irreverent, but that's because he was my law school roommate, he's my son's godfather, and he does whatever I tell him to do. I'm without a fight. He's still practicing, he's still sitting on the bench, so I would encourage all of you not to be that way.
Oh, no, please.
So, you've got a forthcoming book, Judge, called The Common Flaw. And the excerpt was sent to folks and their materials. Why write it?
Well, it's not so much that I wrote a book with some ideas in it. I had some ideas and decided to put them in a book. I spent 6 years doing complex civil litigation, and now I've got 2 years under my belt doing complex family litigation. I learned some lessons, some of them very painful, from dealing with the costs and the lengths and the ins and outs of litigation. And about 40 years of being in courts experience led me to think that maybe there is a reason that people are dissatisfied with the way we're doing things. And that maybe you get the sense, as I do, that there's some loss of faith in our institutions. And so my idea was to sort of pass along the lessons I learned, and also to encourage and to try to come up with ways to help build faith in our institutions.
So why call it The Common Flaw? What's the common flaw?
I love the bit of wordplay, so of course you may have guessed that it's based on the common law, which that's supposed to be Oliver Wendell Holmes on the cover, and that's his great book. It's also a tribute to Justice Holmes, because Justice Holmes was one of the great pragmatists, along with Louis Brandeis and others, who believed that courts should be problem solvers. And so it's a kind of tribute to Justice Holmes to call it the Common Flaw, as opposed to common law, but the other part of the title is very important. Needless complexity in the courts and 50 ways to reduce it. Please remember, as we have this discussion, that my point is about needless complexity. Sometimes there is needful complexity, but the book is about enumerating and above all trying to propose solutions to need less complexity.
I want to read an excerpt from the preface. This book gets pretty far down in the weeds. It goes there because it's the weeds that are choking the litigant-centered humanity out of courts, with snarled complaints, tangled motion practice, choking discovery, smothering trials, and stultifying legal rulings. These weeds have been there. The problem is they're getting thicker and more prolific. That's a loaded paragraph. What is a litigant-centered humanity? What do you mean by using those words?
Well, I try to evolve that into a point of view about what I think courts should be doing. And I create essentially, and this has gelled in my mind more and more over time, that what's going on is, or what should be going on, is a battle between formalism in court and humanism in court. And my book is about bringing humanism in court. To make a simple explanation of what I'm talking about, is that humanism starts with a basic, simple human value. And most lawsuits, if you look at them, boil down to things that I learned as a cadet, which is that you don't lie, cheat, steal, tolerate those who do. If you add, don't injure people to it, you have almost every lawsuit that I have ever run into. So there's a basic human value. And the idea of the humanist lawsuit is to take that human value and apply it to human beings that are in front of you with notions of paying attention to the impact on these humans and the humans that may come after. Now, you may think that theoretically that that's exactly what we do, but contrast that then with what I believe is formalism. If you ever have gotten a sense that a lawsuit is more about itself than the underlying problem, that's formalism at work. Let's say you have a case and it gets brought and there's a motion to dismiss. The court has, this happens more and more now, the court has no jurisdiction because I'm right and the plaintiff is wrong. There's no jurisdiction because, for instance, there's no cause of action. It gets tried more and more. And that loses. Then you tried the motion to strike. And the court writes back and says, oh, I'm happy to entertain your motion to strike, but you didn't do a request to revise first. Please file a request to revise. By the way, each one of these takes months and months to get done. So then the request to revise is done. The revision's objected to. It goes back to court. More months go on. Finally, there's a ruling on the request to revise. The revision is made. The motion to strike finally gets filed. And what do you get? An amended complaint. And then you start all over again. Maybe sometimes you're going to get another motion to strike. And there's going to be a motion for summary judgment later. In my view, that's formalism, and that there are ways of seeing that that doesn't happen. So in a nutshell, it's humanism versus formalism, where you try to get at the human-centered problem as quickly and efficiently as you can, and to answer. And if you look at most lawsuits today, 99% of cases, as you undoubtedly know, don't go to a trial. And maybe that's nice because they settle and things like that, maybe. But the bottom line in many of those cases is that the parties to the case never get an answer to the underlying dispute. They're told they've got to settle or they get thrown out. That's not too long-winded on that one point, but that's the point.
I was expecting to be long-winded.
By the way, what you said before about not insulted me, please insult me. I'd be happy to have anyone disagree or bring anything up at any time, because that's how we do it. So, go ahead.
Well, one could take away from what you just said is that we should do away with the adversarial system. We don't file a motion to dismiss on a cause of action we may think is questionable. We don't file a request to revise to put that motion, to the extent it wasn't a motion to dismiss, in the proper perspective for a motion to strike. And we don't file a motion to strike. Instead, we give you an answer, you bring in the parties, you hug them, and reach the results.
Humanism and humaneness aren't exactly the same thing, but there's a kind of humanity you'd like to think of. A human-centeredness is the point of it. Never involves hugging. I'm not much of a hugger, and but the point is, who needs the request to revise? Why do we have all of these multiple steps when, frankly, in my view, you need one vehicle? You can file it more than once when it's appropriate. One vehicle, a motion for summary judgment. So you come into court. Oh, go ahead.
Let me speak for history. I was on the State Bar Committee, which first came up with the idea of having a motion, a request to revise. And the rationale at that time, whatever it's worth, was at the very early stage, it's like the first thing after return date, to obtain a clarification of what the claim was all about. That was the purpose. It may have been abused over the years, but historically, I thought I should mention it.
Yeah, so the idea is that the request to revise is a way to get a clarification of a complaint. And to me, that if you really want to find out about what a complaint's about, is the process of discovery. If you want to throw it out of court, you go to the court at the initial conference and say, look, this is purely a question of law. I'd like to do a motion for summary judgment purely on a question of law and do it now. The court might say, look, there's an absolute privilege, there's an absolute immunity from suit, file. Or the court might say, wait, it's a more marginal kind of motion. You know what we'll do? I'm going to order some very specific discovery. Because, of course, a plaintiff would want to say, I need my discovery. You can't just throw me out of court. So you give them some discovery, and you have a single motion for summary judgment. Once it's decided, the legal question might prevail, but you also might make the same decision supported by the failure to show any disputed issues of material fact. One motion, it gets over with. So the point is it's not to knock the life out of lawsuits. If you think life consists of filing these serial motions over periods of years, it's to knock the stuffing out of lawsuits. And in my view, most of what goes on in the lawsuits these days is stuffing.
My question was that you have taken the adversarial process on the plate, because if I have a cause of action that has a jurisdictional defect, why do I have to go through discovery? Why can't I file my motion to dismiss? And failing that, then the motion to strike. Why would I give up bullets in my
Well, the point is that, you know, if you have a pointless arrow in your quiver, it's not worth using. In other words, if in fact there's no jurisdiction, if in fact there's no cause of action, and what I'm talking about with a summary judgment throws you out of court, you don't get into discovery. So the point is just like in federal court,
you do, because a motion for summary judgment doesn't state discovery. A motion to dismiss does. So, and in a plaintiff situation, the granting of a motion for summary judgment cannot be corrected by the complaint.
Good point.
Right.
So
you've written out the practice book that provides protections to both plaintiffs and defendants.
not at all, not at all. If anybody here thinks that a judge can't say, I'm staying discovery while I hear this motion for summary judgment, they got another thing coming to you, because of course the judge can do that. You can say, all right, we're going to stay discovery. It's a pure question of law here. I'm going to resolve that question, get over that question. Then we'll get to the next thing.
How do you deal with the case law that says if it's a pure question of law, then you should have filed it as a motion to strike, not a motion for summary judgment? You ripped off the plaintiff of his right or its right to replead, you filed the wrong motion.
So in other words, let's say you just have a failure to state the elements of the cause of action. To be honest, in those cases, I believe in getting the judge involved in an early process. And if there are 4 elements to a cause of action, and the person listed 3 of them and could easily have listed the 4th, then why wouldn't I give the person simply a chance to replead right after the conference, as opposed to play the game of saying, I struck you because you forgot this word, now you're gonna file all over again. And that happens 1.5 years later from the thing first getting raised, when the judge could say, look, you've got this minor error in this thing. You really want to file a motion to strike so that the guy can go back and put the word in? Now, remember, when the person has no facts to plead and can't make a claim for all those 4 actions, then it's a perfect example, something that gets tossed out in a question of law. But the problem is that you have serial motions, one after another, each of which can take years instead of cutting to the chase. Is there a pivotal legal issue? Is it going to kill the lawsuit? Let's get at it. Is it a mixed question of law and fact? Do this discovery. 6 months, we'll have a summary judgment motion. Case over. Sorry, go ahead.
What do you do in a situation where you have a less than artfully drafted complaint and the plaintiff has put 5 or 10, I've seen, sentences in one paragraph that you're supposed to admit, deny, and some of which are unnecessary background? Do you get an order from the judge without a request to revise? Do you sit down with your adversary, right, and try to convince him to clean up his complaint?
And while you're answering that question, you refer in your book to something called snarled complaints.
Yeah. All right, I'll move on to snarl complaints as an address.
Right, but let me just, and 90% of the complaints that come before you are confusing and require some type of revision.
Yeah.
So what is it that 9 out of 10 of us are doing wrong in this book?
Well, you're putting these Rubik's Cubes in writing together. Does any of us here enjoy reading a complaint? These things become so complicated, they're like trying to solve a puzzle every time. And then we worry that I have to give in my answer a precise, admit, deny, or I can't put an answer in that says, I have no idea what this thing says, so therefore I can't admit or deny. And that's, again, to me, that's a kind of worry about form over substance, and no judge should say, you didn't give a clear response. You didn't give a clear response to that claim, and therefore I'm going to do something to you. You might say the complaint's very badly written. I've had that with self-represented parties. I had one where the guy submitted like 78 pages of just absolute nonsense. And so, as the judge, you also have the power in the practice book to say, get rid of that complaint, start over again. You've sued 5 people. I want 5 counts. Tell me in the count what they did wrong to you, in your own words. And you can fix them that way. Judges have the authority to just say that. So at conferences and things like that, judges don't have to say, well, you didn't file a motion about that. I mean, you can have regular conferences, status conferences, just fix it. The guy can't answer. Or not get so upset when you didn't quite answer the way they wanted.
Then we run into problems where a complaint is drafted too simply, containing multiple causes of action in one count, all of which have different statutes of limitation.
Yeah.
And there's no way to strike them, there's no way to get clarification.
Ah, that's because you believe, as some Superior Court judges do, that you can't strike a cause of action that runs through more than one count. They all have to be, this is one of the things that they request to revise this. They move everything into separate counts, so then I can strike it. I've always taken the position, there's no authority that compels a judge to say, separate these things out in counts so you can strike it. You can say, all right, you have a claim here for tortious interference with the contract that's mixed up with some other torts. I'm striking that part of the complaint that's based on tortious interference with contract. Right?
But then what you have is a judge defining what the causes of action are when the person who wrote the complaint doesn't know what they want.
Well, not necessarily so, because, in other words, if you're moving to strike and you want the court to determine that this pleading does not allege a tortious interference with the contract, that's what the judge does. The judge doesn't say, well, I'm gonna rewrite your complaint for you and call this one tortious interference and call this one breach of contract and stuff like that. The person moving against the complaint would say, I want you to hold that this is not sounding in tortious interference. You see, that's what we're doing. All right, so about complaints. So why is everybody moving the rules?
That thing you just said, that the person moves to.
Summary judgment.
Okay, right, so he's written out the question rise, motion to strike, and motion to dismiss. And in this, you
I haven't written them out. I put them into one motion that takes a year instead of 5 motions that take 5 years.
in this utopian view of the world, where you have ample time to sit with every one of the cases that come before you, speak to the litigants, talk about their case, not violate any rule that occur too much that you get disqualified from handling the case down the road. When is it that your colleagues are supposed to have all the time to do this? And by the way, have you talked to any of them about this?
Most of my colleagues won't talk to me, but I'm kidding. We talk all the time. We're always putting our ideas back and forth. But you know, the thing is about judicial independence is wonderful. I don't have any business telling them what to do. What I'm advocating for judges and for lawyers is that we look at our own habits and we try to consider changing our own habits in ways that will make the system work. Because I'm not advocating any rules changes. I don't think we need any acts of Congress or the state legislature to do a better job. We have the power within what we have. And you said that that judges are too busy. They're too busy with choking discovery, which was our next point that we were going to talk about. And my view about discovery, which if you have the answer,
We're still in utopia, so stick with that.
Well, I'm saying we make time,
when your colleagues in sitting in one of the active courts are, responsible probably for, divided up all the civil cases, maybe 800, 900 cases a month. How do they have all the time to do all this hand-holding, thinking, posturing, helping, hugging, which you say you don't do? How do they do all that?
when we get to getting rid of choking discovery, I'll tell you, because the point is that an overwhelming amount of time is taken up in every case in fighting over discovery. And I found on the complex litigation docket, where I first started experiencing it, by saying, look, don't file that motion to compel with the person on the other side saying, I need another 60 days for my brief, and then the other party says they need another 60 days for their reply, and then you have to get on the court's docket some 90 days later. I say, call up my clerk and I'll talk to you tomorrow. I did it in person, but now I do it mostly by video. Here I am, what is this dispute about? And when they say, it's about interrogatory number 47C, I say, no, what is this dispute really about? Because you'll find inside of every discovery dispute, there's a real issue. And you're trying to get at something, and you say it 47 different ways. So what I say to litigants in these conferences that you can get in like a day, what do you want? I don't talk about paragraph 47, subsection B, and then I issue an order. And when the order is written by the judge, it's far less likely to get questions. What did you mean by the words related to? That sort of stuff, and we all have experience with it. They follow the judge's order. And once you start saying you can get me for a conference in a day or so, you know what happens? You get far fewer requests. The parties tend to work out the discovery. So on complex litigation, my burden of having to deal with discovery went like this, down to hardly anything. So you free up enormous amounts of time by taking 5 motions and only having 1, and taking discovery and dealing with it in the manner I said, and I can talk more about discovery in a minute, but anyway, that's my answer.
So in 1993, the federal court adopted Rule 16, which is this conference the courts are supposed to have when the case is first filed, and it was embracing your utopian view of the world, and the judge is going to read the complaint and talk to the parties and figure out whether you really needed 8 causes of action, or 3 would do, and 12B6 motion necessary, or can we go right to something else? How many people in here have had a meaningful Rule 16 conference in the last 10 years? Raise your hand. That's what I thought. None. How is it going to work in your world and didn't work in the federal world?
Let's have meaningful conferences. How about that? That's one way to do it.
But
In other words,
what's the reality? The reality is that you had the federal rules change to embrace exactly what you're saying. And for some reason, at least in the District of Connecticut, it has not worked.
because everybody ignores it, that's why. It's an opportunity to have these discussions, and it has to be led by the judge. Now, I tend to talk to people about, all right, so you've got a key legal issue. How can we tee that up? Is it an independent key legal issue that we should deal with on summary judgment? Or is it entwined enough in the facts that I should order some discovery? But then I start with, once we get beyond the legal issues, because what happens in these Rule 16 conferences, say, all right, we give this schedule, you can file your motion to dismiss on this date, I'm talking state rules now, then your motion to request to revise, then you're on the following dates, that's what you get out of it. Instead of a broad overview of what the real problems are in the case, but once I've talked about those legal issues, those pleading issues, I then go on to say, now let's talk about discovery, and I say, what do you want? Not how many interrogatories you'd like to serve, not the date you're going to serve. Tell me what you want. I practiced in federal court for 20 years in complex cases. And the thing I wanted most to have all to start with was always documents. And you could almost always describe what those documents are without killing yourself. What do you want? I want all the drafts of the contract. I want all the communications about the drafts of the contract, the communications between the parties, and so on. I mean, every case has its nuances. But then what I do, and I'm doing this now, and I've done it 2 years now successfully, I think, is then write an order. You're going to produce the following thing within a couple weeks. It turns out to not be so hard. The mess becomes when you get this, give me all documents related to, well, can I have another 60 days to respond? Okay, that goes on for months and months. What does the response say? Everything, including the definitions, are objected to as overly broad, unduly burdensome, vague, and not reasonably calculated into the discovery of this evidence, right? And then you have to go through this conference stuff with each other, where you send each other passionate emails that you think the judges later are going to read, and they don't. But they're going to go on and on like paper over the discussion you're having about this dispute. And then finally a motion gets filed, the briefing goes on for months, you finally get on with how to do it. And that's how you save time and none of that. If the parties, what I do is I issue a preliminary order, and I say, look, if you want something else, ask the other side. If the other side won't give it to you, write to my clerk, and I'll hear you within a day or two. And again, they stop asking because they know that they're going to have to produce them, right? So the number of requests goes down like that. Was that an answer?
What's your answer? You described the discovery process as the lawyers playing the game of chasing the cheese, mouse chasing the cheese, and the court sitting idly by.
Tom and Jerry.
Yes, idly by, not doing anything about it. So, assuming we were all before you, and you told us exactly what the case was about, and you told us exactly what discovery was, and then it got transferred to another judge who didn't subscribe to the Moukawsher theory of litigation, and most don't. So we're stuck in that world where it's 2 months of motions to compel, briefing, and passionate emails. How do you change the system to fit what you're describing as a more perfect solution?
This is one thing I didn't understand in practice, and I learned only when I got on the bench. Ask. So in other words, if you get a hold of a caseload coordinator and say, you know what, Your Honor, could you do it this way? And most judges are actually surprisingly nice people, and they actually want to help. If you ask them a specific thing and say, would you mind having a quick discovery conference where we just talk? I don't know anyone to say no. Could you issue some orders, some preliminary orders on discovery? I don't see anyone who say no. Maybe there are some. But the hope is that what you can do is, this is the thing I really didn't make enough use of when I was a lawyer, asking. Would you please try it this way, Your Honor? Would you be willing to accommodate us by doing this, that, and the other thing? And then, of course, by then they'll read my book and then we all solve. Just kidding.
But you mentioned we should call the case manager. I'm not aware of.
Caseload.
Okay. So we call the caseload coordinator and find some judge who's willing to take on a case to which she was not assigned, that is, in the calendar, I think most people would say has not worked in our court system.
Which I think is a terrible mistake because it does work when it's done.
Okay, so I'm still trying to figure out how we move from dreamland, from reality to dreamland.
Okay, so the book, I mean, I guess the essence of your question is how do you find the judge? Well, I mean, I can't guarantee, nobody can guarantee that every caseload coordinator does their job perfectly or that every judge is ready, willing, and able. But I find that in most courthouses, there are particularly senior judges and judge trial referees, they're waiting and want to do something. And they're ready to help people. People aren't, this happens in my courthouse, and it happened in every courthouse I've been in all the time. So the caseload coordinator will send out an email to all the judges. Do you have 10 minutes to do such and such a thing? Usually, you know what happens? There's a competition. 5 judges respond and say, oh, I'll do it. So I don't think we should be terribly pessimistic about it. I think if you ask, you will receive.
Okay. Let's all convene next year.
Well,
each of us going to go back and call 10 judges.
don't call the judges, talk to the case coordinator, especially when you have, see, I mean, I've had the luxury of having a full-time caseload coordinator or a court officer, which is an enormous help. And I think we could do better by your being able to get directly to the person responsible for the judge. That's been hearing your stuff and communicating. The branch has to do a better job with some of those things and be more responsive. But you know what? They really do listen to you all. The branch is very responsive to what the bar presses for, or at least the bench is very concerned with the bar. They really are. And if you ask, well, most times, I mean, I don't know, if you all been asking caseload coordinators, they hang up on you, they won't talk to you, they won't do anything for you, is that, if that's widespread, I'm curious about that. So that may happen in some courthouses, in some caseload coordinators, but I'm sure hope it isn't happening anywhere. But if it is, it's something we need to fix. And if you go to the appropriate leadership of the bar, goes to the chief court administrator and says, look, here's some small things we'd like your help.
Before we leave discovery, let me ask you, there are some cases out there where lawyers have been found guilty of malpractice for not turning over every cell. And if we adopted your view and asked 5 interrogatories of the key issues and didn't ask that 6th question, or maybe we didn't use the term relating to or concerning, whatever one practice one uses now. And that was the one thing that wasn't produced because instructions were too light or the interrogatories were too few. You take not filing a motion to strike, and therefore leaving ourselves into a motion for summary judgment. How do you protect us when we adopt this view of a simplified, humanist motion for summary judgment centered case?
Because you still get to move to strike. In other words, you just don't get to do it 4 times. You don't do 4 motions, you do 1 motion. And the point I'm trying to make, and what I've been urging the courts to do, and what I write about, is about needless complexity. It's the needlessness. In other words, you didn't ask, if you think that you're in the malpractice case, that you're gonna be able to defend yourself by saying, well, I did serve 453 interrogatories, or it was a great trial, I got 750 useless exhibits into evidence. The amount of stuff you're doing is not a measure of whether you committed malpractice. When there's an obvious question of law that takes down a case, well, of course, you should be raising it, and the court should be applauding you and giving you the chance to be heard on that. So it's not so much taking away tools, it's how you use those tools, and how you use those tools to make lawsuits efficient. And if lawsuits were efficient, by the way, legal malpractice cases would be efficient too. And your carriers wouldn't be out there saying, oh my God, we got sued. What's the cost of defense? What's the cost of defense? How many of you spend great periods of your time saying, what's the cost of defense value? The cost of defense value in cases many times exceeds the risk of loss. So you end up spending more time on evaluating the cost of defense than you do in spending time on the risk of loss. It would be the same in malpractice cases too. For this malpractice case, get it right to summary judgment. It'll be over in 6 months. Get discovery, yes. It'll be court-ordered discovery. So when you're worried about not serving interrogatory number 322, what I did, malpractice company, is I asked the court for orders of discovery. The court crafted the discovery orders, not me. So you don't have to worry about interrogatory number 423. But I fear that all of us, every one of us who's practiced malpractice, and those of us on the bench, confuse volume with quality too often.
I'm sorry, confused volume with,
Quality.
thank you.
To that point, and somewhat tying in with the malpractice, is that, is there any evidence that people who take the approach that, with these 4, 5, 6 motions to strike lead in problems? Does anybody know if it's actually effective? And if it is effective, there's no reason for us not to be pursuing it, to this point about
No, I think it's mostly just a bore. What happens is you forgot about the motion from last year by the time you get the new motion. It takes so long for a motion to go. It's not punch, 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 all right, you're bound to land of blow. Especially because we're not using IndyCal the way we should be using IndyCal. The judge who saw the first motion isn't going to be the judge who sees that third motion. So it's not going to have that cumulative effect. And by the way, defenses to lawsuits that include every conceivable defense, because you're worried about malpractice, you actually should worry about winning. And you actually undercut your chances of winning by raising frivolous defenses because you think, well, theoretically, I should throw it in there. What judges do is they roll their eyes and say, well, maybe I should just deny them all, or this person just keeps coming back. Believe me, judges are sensitive to the people who keep just come back and find another highly technical, endlessly brief motion that's just wrong. And you have to deal with one more of those to say, you know what happens? And because judges are human beings. Say, here comes another one from old so-and-so. You don't want that part.
Maybe you do. Maybe if you're a defendant, that's the way you're going to whittle down the plaintiff's case. Maybe that's the way in which you exalt all the rights that the practice will give you.
Well, that's the Donald Trump defense to lawsuits. Make them so complicated, make them so complex, make them so expensive that the parties will just throw up their hands and run away and give you what you want. I don't like, I don't think it's good for your clients, because what happens is, starting from the defense end, you fought, everything you could possibly do. And then by the time you get to the trial, you get to the time of trial, and somebody says to you, client, I know we spent a few $100,000, but now we're gonna go to trial. I need a $500,000 retainer to try the case. And the client says, are you kidding me? And they said, well, we do have this alternative. We could settle. And this is what happens. Everything is wrung out of the client before you get to the part that ought to count. And then the client's left helpless and has to settle. I don't think that's good for the clients. I also don't think, I'll speak one quick point, because I also don't think it's good for the lawyers, because who wants to go to court anymore? It's too expensive.
Isn't it because it's a system of litigation and not a system of trial? I mean,
That's right, in other words,
I was reading.
oh, sorry, let me repeat your question. The question is, it's a case, it's a system of litigation, not a system of trials.
Yeah, because like back in Abe Lincoln's day, right, you're on a circuit. You go into a town, find out what the disputes are. You borrowed Tim's tractor, you never gave it back, and you gave it back, and you screwed up the bucket. We don't have discovery, we don't have this, no motions. In 3 days, we're gonna go in front of a jury trial. And now it's.
Well, that's right. In other words, what I formulated in my mind over time is with litigation after litigation. This is a case about a case. It's all about what happened in the case. And the underlying human problem, this is the underlying human problem that prompts, which could be from a company or from somebody else, gets lost in the shuffle. And it's the case about a case. And then when the case is over, whoever wins, if the defendant wins, they file another case about vexatious litigation. You know, a case really about a case. So I think that's killing business. That's the thing I'd like people to really watch for, is that it's killing business. People will do anything to avoid having to go to court, and that's not good for lawyers.
Let me just take a pause and tell the people on Zoom that the verification code is lawsuit. Question?
Yeah. Bring back the teeth in the offer of compromise. Let us get interest from the return date and make cases to settle suit instead of having to wait whatever the waiting period is.
Well, that is the thing. That's the other aspect that I don't think courts have any business spending, which is that we'll drag the case out as long. We'll pay later. We'll pay later. Appeals suffer from this terribly. If we had a more efficient system, a system that gets rid of as much needless complexity as we can. And I'm not a complete fool, we're not going to fix everything, but the point is that the less complex it is, then the faster you get to an appeal. If the appeals go smoothly and quickly, you get fewer appeals. The whole system works better because the time on an appeal is free money sometimes, right?
Let's jump to what you call smothering trials. What do you mean by that?
I'm not going to mention any specific cases when I think of smothering trials, but some people in this room know what a smothering trial looks like. I've had cases that have just lasted endlessly, thousands of exhibits. So my first point would be exhibits. And I'll say this controversial thing, we almost never need them. Ask yourself about the last trial you did and how many exhibits in it were to prove a disputed point, or were they for the record? Most times at the beginning of a lawsuit, the parties will say, we have 500 exhibits and we'd like them all to be admitted for the record. And the judge is sitting there like, what are they about? And sometimes they never learn what they're about. But the most important thing is that they're usually about something that's undisputed. So what I have tested now for 2 years, and I've had about 50 trials, is a system of trial admissions. And these aren't contention admissions. These are admissions of things like the bank account on March 1st, 2020 had $50,000. You have a bank account at M&T Bank, it's got $50,000 in it on June 1st, 2020. On July 1st, 2020, it had Zero. You shouldn't have to have either an exhibit to prove that, nor should you have to have testimony to authenticate the bank records. And nobody's going to challenge the end of anything. The court needs to encourage the parties and demand that they, in good faith, work together on these things and admit it. And it's up to the court to police this sort of thing. But they should never have to sit there and have somebody authenticating their bank statement only to, at the end of it, to offer it in evidence and have the other side say, no objection. But if we spend all that time, same thing on many, many other things. I'm talking about the undisputed. It's not contention interrogatories. Admit you never loved me, or you had a negligent smirk on your face around the court. Not that simple. The nuts and bolts. Think about the exhibits left in the last case. How many of them proved a disputed fact? When somebody sent in an email, it's almost never disputed. The contents of it can be admitted. I wrote to you on this date and said this. So let me give you an example of what a question might sound like if you actually used the admissions process where you just simply admitted. You'd have people testifying things like, okay, January 1st, 2021 was a clear, sunny day. A plaintiff, I'll call mother named Jane Jones, was driving down Main Street in East Hartford at 9 a.m. in the morning. The road was dry, the road was straight. There was a traffic light at the intersection of Main and Elm. That's never going to be disputed. So what you do is you have the witness on the stand and say, this date was a warm, sunny day. Main Street is straight. It intersects with Elm Street. There's a stoplight there. So you say all those things, and they said, did you see the stoplight as you approached? Instead of spending all the time. Do you recall the date of January 1, 2020? Yes, I do. Anything unusual happened to you on January 1? Yes, tell me what unusual thing happened to you on January 20th. Why not the cars? No, not so fast. I got in my car. It's a gold Supra. I drove down here. All that stuff, instead of getting at the thing you want to know. Did you see the traffic light? What did you do in response to it? The bank account was drained. That's not disputed. Where did the money go? Your tax return reported $150,000, but your bank account showed $250,000 of receipts. Where'd the other money go? See, we spend all the time showing the receipts. We spend all the time showing the bank account things. When if judges insisted that in good faith, people admit these things that they're ultimately going to admit anyway. And the way I deal with it is, are you going to dispute this? Are you going to offer the evidence that this is not really their bank account? And the answer is always no.
So if I'm a plaintiff's lawyer, I want to ask those questions because I'm developing a rapport with the jury. And I want to have the jury understand, appreciate that plaintiff, and feel for her. There's the Kennedy Rick case in White Black. There's probably some of you don't remember this case. White Black, Kennedy leaves the house, then goes back into the house. White Black wants to establish that this thing, this leaving, go back in the house, pick up the stove, whatever he did. The probably took 2 minutes, took 3 days. So, Mr. Black, or Mr. Kennedy, you left the company, yes I did. You went to the parking lot, yes I did. And you reached your car, yes I did. And you turned around and got your keys, yes I did. You walked back into that house, yes I did. You knocked on the door, yes I did. And where her name was, over the door, yes she did. And you were in the foyer standing with her, yes she was. And you were together in the foyer, yes I was. And then you remembered you left your keys in the living room, yes I did. And this thing that literally walk in the door, get my keys, he was trying to establish that there was no way this rape occurred because she was with him for another 3 days, which was only 3 minutes. So your theory, if I had just said, All right, well, I went back into the house, got my car keys. He
I-
loses that case.
No, I wouldn't do it that way. And by the way, you're not going to build,
But who gets to decide? You, the judge, or us, the lawyers, who are defending or prosecuting that woman who just got into a car accident? And I'm trying to develop a rapport with the jury, you're telling me, say, so, clear date, after we got this red light.
so here's what you ask them, instead of whether Main Street is a straight street, whether it was a sunny day, or whether there was a traffic light there, you ask them, so what did your morning been like so far? Tell me a little bit about your background. Have you been driving long? What do you do for a living? Make a report with the jury.
What do I do for a living? That's not disputed. I'm a mechanic.
So what were you thinking? You're on your way to work.
I'm driving, I'm not thinking, I'm concentrating.
Well, you got a lousy witness, I can't help you there. The witness would say, I was thinking it's my daughter's birthday and how much I want to spend the evening with her. And so I was being particularly careful as I drove down Main Street where I'd once seen an accident. I had both hands on the wheel. And, but it shouldn't be about, you're not gonna build a rapport with the jury by asking the witness about their bank account. Is that your bank account? This is my bank account. How long have you had this bank account? Is that your bank number on it? How do you know that's your bank number? You're not gonna build a rapport with that. What you should be asking people are questions that start with things like, why? What were you thinking? What were you feeling? Why? Not the basic objective facts such as a road called Main Street in East Hartford.
There's a problem with, I think, where you're starting from, and just in my view. You're relying on good faith. In your average, simplest motor vehicle case, you file your complaint, defendant files the answer, what they don't know, they deny, including whether or not they were even driving the car at the time of the accident, everything unknown, and the judges do nothing about that, they don't care. You raise that later on some motion, and the judge says, well, that's just pleadings. When it comes to defense counsel, that's just pleadings. So then you.
Well, why wouldn't you, let me just, because you're asking about a thing that comes up where somebody is not answering the complaint properly and they deny things that they don't really deny, and the judge doesn't do anything about it. A time when a judge can do something about that is in the jury charge. And by the way, ladies and gentlemen, they denied that in the first answer. They've admitted it 20 times over.
They don't even let you bring that into evidence at the trial.
Yeah, you could ask. I can't guarantee.
I've asked.
But you had more.
Over and over and over again.
Yeah. Well, it depended on to me, it would depend on how unreasonable that was. I wouldn't just say it's just me. How unreasonable was it? You denied your name was Tom Jones?
So, I mean, after that's done, you got a motion, even before that, you've got a motion for extension of time to plead, which since COVID, in every single case I've brought, asking for 60 days on top of the initial 30 to plead when you get exactly what you were gonna get within 2 days of your filing the complaint.
Which is a request for a vote.
Scheduling orders that 50% of the time the defendants don't even respond to, and by case flow's suggestion, I file them without even calling defense counsel because they don't respond. You're relying on good faith, where in practice, I don't think practicing bar can rely on that good faith.
Well, if you're talking about good faith from the courts, I hope we can ultimately rely on good faith from the courts. And if we're not getting good faith from the courts, we should demand good faith from the courts because they work for everybody. They work for the public. And yes, it's never going to be perfect. But if it's good faith between the parties, then that's the judge's job. And the judge, what I have done is I can see a pattern of somebody who simply won't agree on the color of an orange when they're opposing counsel. It has consequences. And my favorite consequence ultimately is when you don't have cooperation and discovery, is to take a negative inference and to say, I'm sorry, but that issue is now foreclosed. And I'm going to instruct the jury on that's a good sanction. I forget, Tim was saying that they're supposed to pay, the defendant will pay $100 or something as a useless sanction. But negative inferences and warnings about negative inferences are good things. I'm not by any means trying to suggest that the bench has got all this straightened out. I'm begging the bench as much as I'm begging the bar. We have to, but if we all show just a little bit of good faith and try out a little bit of our own, change a few of our own habits, don't try with everybody.
Scott. Thanks. Your Honor, going back to discussion of good faith, one of the issues is with trial admissions and I guess sort of also the stuff they do in federal court when you put together a trial management order, is that nobody can ever agree on that stuff. And you spend so much time and energy on the what everybody agrees on that is detracting from your actual trial preparation, A, and then B, by the same token, hardly anybody ever stipulates to anything. So you gotta sit there, walking all those bank statements through, and then the judge looks at you and says, why didn't you guys stipulate? And I'm thinking, because I asked him to stipulate, he said no, on bank statements.
So the basic question is that there usually isn't a lot of stipulation, but an awful lot of effort goes into stipulation. And I understand that. I'm advocating a change of that world, and the world that needs to change is with the judge. I have a trial management conference in which I go over specifically the kinds of things I expect people to admit. The contents of a bank account, the statement made in an email. And if a party isn't reasonable about that, again, the sanctions are things like negative interest. So you wouldn't stipulate to what the bank balance is. It's a fact, that's the bank balance. Because you didn't act in good faith to confer about it. You came in here instead of saying, I tried in good faith, but I actually think that's not the bank account statement. Nobody ever does that. They end up saying, that's the bank account statement. And so the judge has to say to them, don't ever do that again. Or treat it as simply proved as a penalty. So yeah, I'm not suggesting there's a perfect bench out there with an imperfect bar. We have an imperfect system that everybody has to work to get down the road you're talking. I have some criticism of judges. Do we have time?
Well, you can spend 4 minutes criticizing your colleagues.
Oh,
Or talking about stultifying new rulings.
that's what I'm trying to do. That's what we do.
Okay. You want to admit that publicly or just talk to me?
We do things wrong. I was looking for my notes, so I'm very careful what I say about judicial decision writing, because it may likely get me into lots of trouble. And I want to say, certainly for the record, that the problems we all stipulate. We all stipulate that I said that there's nothing wrong with the writings of our appellate courts. I love their work. And I only have one suggestion for what they do every once in a while in my case, is that they should omit the word reversed. And I'd be very happy with what they write. But so I guess if there's a big point I would make about legal rulings that, by the way, applies exactly also to briefing. Things that are choking the life, choking the humanity out of briefings. And briefing and decision writing, in my opinion, can be described as in part in this way, which is that you should use the information on the procedural posture, the evidence, the claims of the parties, and the legal standard only when they're needed and only where they are needed. So what I would say is there shouldn't be an opening paragraph about the procedural posture. There shouldn't be separate pieces on the standard of review. There shouldn't be a summary of all the evidence that went into trial, even if it's not going to be used in anywhere in the judge's decision or in the briefs. If you're not going to talk about it, please don't include it. If the summary judgment standard you're going to make is purely a question of law, don't put in your cut and paste section on leaning toward the party that is the non-moving party, because you don't need it. And when you do need it, use it when it comes up, not these disembodied sections. And this is the same way judges opinions on the procedural posture, on the applicable standard in law. Usually, especially courts, not others, go way out of their way to talk previously about things that have nothing to do with this case, about the legal standards and backgrounds, and then a summary of the parties' pretensions, a summary of all the evidence and witness testimony. It's disembodied. What you should do is work these in where they matter. You're making an argument for something, and you weave the standards and conclusions into it. You never get to the heart of a judicial decision in most states until page 40. I actually literally did this when I was writing my book. I took a map out and I went like this, and I hit Indiana, and I decided to just randomly pick an Indiana Supreme Court case. And it's the same way as most places in the country, the same flaws. You almost can't find the reason. When I was a young lawyer, I used to end up reading these things, telling my clients, I think he just didn't like me. That's why the judge didn't. Or he likes employers, he likes employees. You end up guessing why the judge did something. The heart of an argument, the human heart of the dispute is usually the last thing that gets talked about. Usually it's the court's jurisdiction, the standard of review, all those things that, if they're needed, use and where they're needed. So that's what I would say about briefing and about judicial decisions in general. I try to take these things apart. So let me just 3 quick points. All courts and lawyers too should drop independent sections about procedural postures, the standard of reviews, the lower court rulings, the contentions of the parties in the background law. Weave it in where it's needed to your argument. You're making a human argument. You're trying to persuade somebody that somebody did wrong or somebody didn't. Talk about that, please. Not the rulings of the courts of litigants. Trial court judges should get right to saying who wins and why, with most of their attention focused on the facts, not the law. Same thing with briefing, because I find having litigated many cases on this, that the basic law is usually not disputed. And what you end up doing is fighting over whether this case sounds more like that case or the other case, which I hate. It's a complete waste of time. Let's talk about this case. There's a basic standard. Talk about how the facts work. That's the trial judge. Appellate courts should identify and clarify and apply key legal principles and stop choking their work to death, not just with the pointless side clips that usually take up most of the earlier parts of the decision, but with a cacophony of confusing quotations from their earlier decisions or the decisions of other courts, when they could be telling us the same thing in their own words and with brief citations to the controlling principles. Sometimes it's like a series of lily pads of quotations from other courts, and you're leaping from one disembodied quote to another, and the court never speaks in its own voice. It's neat. So those are briefing and
Stultifying legal rulings.
so far really in it. So
Any other questions, folks?
I have one final statement.
Is this the country you're establishing for this view?
Yeah. I'm going to start a small republic. I'll go chill out. So I just wanted to end just by briefly saying that I certainly don't expect you to agree with everything I'm saying. I certainly don't expect everything I've suggested to be adopted. But my goal's been simple, which is I think after 40 years or so in courtrooms that I've learned some lessons and I want to pass them on. I really don't have any other purpose of doing it. If you learn one lesson from anything that I've said, let it be this. It's a troubled time when people are losing faith in our institutions. And if you learn one thing from what I've said, it's that I believe each of us can improve the respect that the public holds for our judicial system without harming our own interests by ridding ourselves of needless complexity. We don't need any committee to do it. We don't need Congress or the legislature to do it. It's just our own habits under the rules we live under. I suggested some changes today, and in the book I wrote, I've got 50 ways to do it. So if you agree with 2 or 3 of them, I'd be delighted. But I certainly don't expect everyone to think everything I've done is great. Lastly, being the foolish and fond old man that I am at this point, I think if you act on some of these little ideas, you might do a small thing toward a very big thing, and that's the preservation of our republic. Thank you.
Probably, yeah. You're gonna have to come back next week.
Oh, yeah.
This just was a travel everywhere. That way it comes with me.
She's in the next office. And I didn't hear her all day long.
Your wife as well?
Yeah, she's another lawyer.
Baseball. Give me a version.
Meetings a day. They know who all the players are. I can even tell from the walk.
Yeah, so, and I hear everything that she's doing, and I'm involved in everything that she's doing. And I get summoned all the time to do this and that. I'm summoned all the time.
I have a grandfather's clock in our house. And I hear it from the decisions I've taken over the last 3 years. Because I do a lot of questions from you know, the big confession is coming. And you hear, one question. Now I have an app that drowns out all the